I watched Speed Racer last night. The cartoons.
I love that.
Did you like it?
Yeah. I was on YouTube watching all the cartoons. It was great.
I grew up with that.
Here comes Speed Racer. He's a demon on wheels. All right.
All right, well, good morning, everyone. We're
John, did you
about
get
ready
that
to
on
get
TV?
underway here.
I did. Good. Scary.
Yeah.
And I believe our first witness is Charles Baker. Mr. Baker, the floor is yours. Do you know where we're going on the committee, or should we introduce ourselves?
No, I'm good. I've at least met you briefly all before, so thank you.
All right, well, what's good for?
Thank you. For the record, Charlie Baker, Executive Director of the Chittenden County Regional Planning Commission. I want to thank the Chair and the Vice Chair and the members of the committee for the time on your meeting this morning. I did my best to read the new version yesterday, so I know I didn't catch everything, and I'm sure I didn't understand everything, but I wanted to get you comments as quickly as possible on it, as I know you have a lot of decisions to make in the next couple days. And just so you know where I'm coming from, before this current job in Vermont, heading the Regional Planning Commission here, I headed a large permitting department in Newcastle County, Delaware, a county of 530,000 people, where we were the primary permitting agency for all of that, and honestly did more permitting than the state of Vermont does annually. So very familiar with the permitting process. And I think one thing I want to say about that is the permitting process and the regulations and changing regulations can really make a difference in your landscape and what you do. So I'm very excited and happy to see that you're addressing Act 250. One of the things that we saw, I looked at data when I got here to see what had happened in Chittenden County over the decades. And one of the things that we saw happen after 1970 was the rate of rural development, small rural development, almost doubled after 1970 in Chittenden County. I can't attribute all of that to Act 250, but it definitely, I think people trying to avoid Act 250 contributed to rural subdivision, breaking up our forest and farmland in Chittenden County. I don't know how it played out in the rest of the state, but I just give you that context, so I'm really glad to see you addressing these issues. What you have in front of you are comments I drafted last night. These are not formally endorsed by the Regional Planning Commission board yet. They are based on some conversation that our Act 250 committee had last week. And so I'm hoping we'll get the opportunity to provide further comment as this evolves. Have a few general comments first, 1 through 5 here. First, as I just said, we really support updating the Act and applaud the committee for taking on this important work. Second, we kind of noted like there's substantive changes, the jurisdiction criteria that you're discussing, and then there's also the process pieces, the district commissions versus the board, how appeals work, and we think if you can't get to agreement on the process pieces, we'd at least like to see the substantive pieces move ahead. The third point is just the broad point. This is kind of a smart growth comment. Our board really supports smart growth development and the trade-off of encouraging development in the appropriate places where we've planned for and discouraging development in vulnerable and valued resource areas. And so we do support the exemption in the areas planned for growth to encourage affordable housing, economic investment, walkable, transit-friendly, energy efficient, water and sewer served areas. But we would like to see that exemption expand a little bit. I'll get into more detail on that later. And then the fourth point kind of goes on the flip side on the resource map. We'd really like to see more clear mapping on the resources so that people are clear what triggers jurisdiction or not, and also assist in evaluating compliance with criteria. And the fifth one, and this one I wasn't sure is in this new version, and maybe I just didn't catch it, that we support the concept of providing presumption of compliance for specific criteria based on separate state permits. And the rest of my comments kind of walk through the version 10.4, 103 pages that you got yesterday here. So please groan at appropriate times if this is too painful as I'm going page by page. On page 6 is the interstate interchange, new jurisdiction. Generally, we don't feel that this jurisdiction is necessary. If it is retained, we'd like to see explicit language around how the RPC determines municipal bylaws meet the criteria for the exemption. We'd like to see language that exemption remains in place for the entire area unless the RPC determines at a future date that the bylaws no longer meet the criteria. So it just was a little fuzzy as to whether this was a project by project review or if this is a one-time review at the front end.
Do you have this in your testimony file with us?
Yep.
All right.
Yep. Yeah, sorry, I'm reading.
That's good.
If anybody wants hard copies, I should have mentioned I have some extra
Actually,
copies
I'll
here.
take one of it now. Thank you.
Yep. I don't know if anybody wants copies around here. Yep, thank you. And as a more general comment around the interstate interchange language, we even suggest, sorry, I'm not scrolling here, that the urbanized area could be used as an exemption to exclude those interchanges from jurisdiction. So the urbanized area, as the census defines in Chittenden County, would include from exit 12, which is Williston, through exit 16, Colchester. So moving on to the next page, in pages 7 and 8 in the draft bill, this is the road 2,000-foot roadway length provision. Good morning.
So sorry.
I'm making an assumption here that we're trying to prevent forest and habitat fragmentation with that provision. And if that's the case, I think we'd really like to see just those forest and habitat areas get mapped and just say those mapped areas may be defined by A&R, maybe after some review or by rule, that those are the areas that are now have Act 250 jurisdiction. We're a little concerned just with 2,000 feet that may pull in some subdivisions that probably don't really necessarily belong in Act 250 just because they have, just because of the size of it in our urbanized area. So, question?
Yeah, I do have a question. I've noticed some things when I'm driving on Dorset Street where it's not 10 houses, it's fewer than 10 houses.
Yeah.
So I imagine that means that they didn't go through Act 250.
Probably.
They're very, very, very long. I can see it's more than 2,000 feet, 2,000 feet at least. And so it's not, it's sprawl, suburban sprawl is what it looks like to me, on really gorgeous land. So, why would you be asking? No, so why are you asking?
We're trying to, I think, try to be clear if there's a resource we're trying to protect, if that's going up into forest land that is a protected resource, then let's just map that resource area and protect it. Or at least make it subject to jurisdiction so it gets into review. So we're just concerned, like, what if it's 1,900 linear feet and doing the same thing in an area that we want to protect? We should say we want to protect that area.
Oh, I see. So basically map the area to protect it.
Right.
All right.
Yeah, that's I think the more important point here. Yep. Comment 8, I have a typo in the line. This exempts the subdivisions in the designated downtowns and neighborhood development areas, not outside, inside. And we definitely agree with and appreciate the support. I had a little trouble seeing, I saw the definition of subdivision, I didn't see the area exempted in the definition of development, so I'm just not sure if that's, I may have missed it. We would
I have a quick question.
yes, sir.
When we get any further ahead, would you do away with the 2,000 feet entirely?
If it's replaced by mapping the resources that we're trying to protect.
Mm-hmm.
Well,
Do you think that would be in lieu of that?
right. and my impression from at least following some of this conversation, definitely not all of it, has been that we're trying to protect rural, forest fragmentation and rural habitat loss. And I think from our view and from my experience previously in regulating protected resources, I did an open space ordinance in my previous job where we mapped the resources and said, don't go there, or if you're trying to go there, show us how how you're going to mitigate it or minimize impacts. And that's a much more straightforward way to do this. And so, sorry, on page 9, with regard to the downtowns and neighborhoods, we'd like to see growth centers and town centers, new town centers, be added to this these exemptions. On number 9, page 11, these are the sections that define the connecting habitat and forest block. And the words there are all great, but again, we'd like to see something more specific and actually linked to the map created by A&R, which I know later on you're requiring A&R to do the mapping. We'd like to see that connection actually happen so that we can regulate to that map. And then also, just a question, there's no minimum sizes or anything, is a forest 1 acre, is it 100 acres, 1,000 acres? And maybe the professionals at A&R have clear definitions around that, but I don't know if the legislature wants to give some guidance about, what's a minimum size of those resource areas. Page 14, comment 10. This shift, from what I understood, shifted the responsibility for jurisdictional determinations from the coordinators to the commissions. We're concerned that this is adding more process than needed, and think the jurisdictional determination process at the coordinator level has been working fine in terms of ease of administration. However, if there are issues of consistency, which I do believe probably do exist, as different coordinators around the state may give different interpretations of jurisdictional determinations, that those determinations should be reviewed by the central VERB, the Environmental Review Board, so that then you can get those more consistent over time as the district coordinators issue those decisions. Comment 11 establishes the Environmental Review Board. We don't really have a position on most of these process organizational changes. However, the one thing that has come out of our conversations that has been a benefit of the environmental court is the ability to consolidate appeals of municipal, state agency, and Act 250 permits into one hearing process. We're concerned about this fragmenting that process again, so that some appeals are heard by the ERB and some are heard by the environmental court. So we're agnostic as to which body hears them, but would still like the ability to combine appeals from the municipal and DEC permits with the Act 250 appeals into one hearing process, so that we don't end up with conflicting things, at the E-court and the VERB, that then have to get to the Supreme Court before they can get rationalized.
Do you favor keeping the E-court in the mix?
It's been functional in terms of this issue of being able to combine the appeals, so that I think we're more interested in the function than exactly who. So as long as they're still able to be combined. Comment 12, pages 26 to 27, talk about the capability and development maps. We appreciate you adding the consultation with the RPCs in those maps. We do think that the RPCs have already done a lot of work on the resource protection areas, particularly in the work that we did over the last couple of years on the energy planning. We were all required to look at what state resources and local resources ought to be protected from any kind of development, including renewable energy generation. And so we did a lot of mapping there already that maybe give a running start to areas that could be included in these, at least on the resource protection side, included in these capability and development maps. And we, of course, also have maps on our future land use maps and development areas, et cetera. And again, just making the comment again about making a stronger connection between which map layers are going to be help with the jurisdictional issues around forest blocks and habitat. Page 34 to 35, again, we're dealing with the exemptions in downtowns and neighborhoods, and also the process for extinguishing current Act 250 conditions. We, again, agree with this approach. Would like to see the growth centers and new town center designations added. So that's really the only comment there. And allowed to be extinguished. Amongst my peers in talking about, I'm hopeful that the municipality providing a copy, I think it's to I can't remember if it was the district commissioner or the verb, with but conditions they're proposing to extinguish. It's not clear, is that really a review process at that, at the Act 250 level, say, okay? Or is it just a notice that we're extinguishing these and the verb or district commission can say, wait, tell me, don't get rid of that condition. So it's just kind of a question of how that works, what the role of the Act 250 is in reviewing or not those removal of those conditions. And I say that in part because clearly the public has engaged a lot in Act 250, and there may be people relying on those conditions being enforced. So, I'm sorry, was there?
So, Charlie, you're silent on a couple things here.
Mm-hmm.
There was some discussion earlier around a concern that an extinguishing a permit in the development areas could have an impact that Act 250 does consider on outside of the area. Classic thing is a big mall at exit 12 in Williston, and how did that impact, or might that impact South Burlington or even downtown Burlington? And do you see a way that we could do this, but put some sort of sideboard on maybe that criteria of impact to the community, or how we, or is that just a bridge too far?
Honestly, I see that as the job of the regional planning commission
Yeah.
when we're doing our future land use plans. Like, we need to come to agreement across the towns about, high development areas and protection areas. And so hopefully those are getting worked out at that level.
At that level with the exemption, and now it's a municipal function, and
Right.
and the RPC and the affected, possibly affected towns would be covering that base.
Yep.
Okay, yep.
So, and I realize, there are those concerns, particularly, suburban malls had big impacts on downtown, for sure. And so I think part of what this is, the overall approach though, is the more we're making it easier to invest in our downtowns and villages, the more we mitigate any of those suburban impacts that happen.
Right. And the other piece that's in there that you're silent on is the part about, if the basic land use is changed from your original permit, or no longer applies, then the permit can be dismissed. You're good with that?
Yeah, and that's, I think just broadly, part of the reason we were supporting extinguishing some of those Act 250 permits. I know I've heard from our towns that there are parcels that are continuing in Act 250 jurisdiction for reasons that were relevant 45 years ago,
Yeah.
but are no longer relevant today. But and right now, they may be in a downtown and exempt, but because the parcel had Act 250 jurisdiction 45 years ago,
Yeah.
they're still in Act 250, which is really unfair. Why that parcel's getting treated differently than the parcel next door that just didn't happen to get in Act 250 during that time frame.
Right. Okay, thank you.
Yeah, thank you. Comment 14, pages 41 to 42, about the 30-day pre-application notice. We do agree with this, and the only concern that came out of our conversation was that that project ought to be vested at the time that this is happening, and just so that rules can't change in those windows. Comment 15 about page 52 about the stronger language for applicants to provide bike, pedestrian, transit infrastructure. We definitely support this stronger language. Page 53, and this is just kind of more of an administrative thing, but this is the one where municipality doesn't respond within 90 days about the adequacy of the educational services. It's presumed to have no impact. We're just wondering if it would be more appropriate to have that request go to the school district rather than the municipality. So actually communicate with the entity in charge of the school rather than the town, who may or may not directly care about the school district capacity. So that's just a suggestion. Page 57 about the energy efficiency, and this, and there's a provision in there that adds a stretch energy code. Again, we're concerned just about fairness and consistency across the state, that the stretch energy code shouldn't just apply to people that are going into Act 250. We'd ask that really move that into the actual statewide energy code and not just in Act 250. And again, I was specifically referencing the stretch energy part. The comment 18 on 58 to 59, we support the municipal plan being approved by the RPC to be used in Act 250. On pages 70 to 71, this is a section requiring A&R to produce resource maps, including the forest blocks. And yeah, thank you for getting those areas mapped. I think that's extremely helpful. However, I'd like to see it be a little back to the jurisdictional definitional piece, get stronger so that we're actually using those maps for jurisdictional determination. And actually, I think it will simplify a lot of work down the road if we know what resource areas we're trying to protect. Comment 20 on page 73, this is where the verb approves regional plans consistent with the goals of Title 24. We support the review, but have a couple suggestions to make the review a little bit better. One, we'd like to see a consultation at least with the agencies that we most directly work with, the agencies having to do with land development, so Commerce, A&R, and V-Trans. And those are really the agencies we coordinate our planning with anyway, so just to make sure we're all on the same page. And then secondly, we'd like to see this be a little bit more consistent with the requirements we have for reviewing town plans, which don't only include the goals, but also we confirm that the plan contains all of the elements required by the state law and is compatible with adjacent jurisdictions. So we kind of look at how do we look at the boundaries and all the elements and all that the elements require are in there. So that's
Question for you.
yes.
That kind of in-depth review now is only being carried out as far as energy components go in either a regional or town plan?
No.
What are some of the other?
Any town that requests a regional planning commission to review their town plan, the criteria I listed is what the regional planning commission uses. So the energy has a whole different set of criteria that were developed by the Department of Public Service.
Yes.
Which is more detailed, but what the language I provided you is what we were doing even before the energy planning work, to approve a town plan.
I guess my question gets to the point of the only the state review that this regional or town plans are getting now is from the Department of Public Service as far as the energy component goes. There's no other, you're not reviewing other issues statewide, we're not getting a statewide review of other town or regional plans. Is that
The
correct?
only state review we get is from DPS, that's
Okay.
correct. Yeah, and so, yeah, we're supportive of, integrating the system a little bit more with the verb, but also think it ought to include those other relevant agencies.
And just one more, how is that working?
With the DPS?
Yes.
Yeah, I think that we spent some time with them working on the criteria, and since then, I think the reviews have been working fine. Hard work's doing the planning, but once we agreed on the criteria and we all knew what we were planning towards, it seems to have gone pretty smoothly.
And you're telling us you would want to roll now with putting together a criteria. Indeed, if the verb was to determine,
We're actually not, what I'm suggesting is not that detailed. The criteria would essentially be what's in state law. The goals plus the elements, plus the consistency with the adjacent jurisdictions. So that, and that is what we were reviewing for town plan. That's how RPCs review town plans now. Comment 21, pages 75 to 76. This is where we get into a little bit more detail about the Municipal Development Review Panel, reviewing the Act 250 permits and their conditions, and either taking them on or removing them. We definitely support and appreciate what you're trying to do here. So I guess we're encouraging that. Again, I had that question about the role of the state review and how they actually get released. Page 97, this is requires A&R to adopt rules for highest priority river corridors. I think this is a step in the right direction, but it did raise a concern, which is currently in statute. We're just not clear enough about what should happen in our downtowns and villages. And so, there's a rub there that I think some additional guidance to the agency. We think actually having this be a separate or merged up with other permitting would be helpful, because right now it's kind of a voluntary program, and the only way that's regulated is if a project is in Act 250. And so actually having a separate permit on this, I think, would be a much more productive path for the whole state. But we need a little bit more guidance, I think, to A&R to consider the implications within our areas that we're trying to also direct growth to or encourage growth in our villages and downtowns. The last two comments are things that I just didn't see, probably because I was reading this really fast and it's really long and it's complicated and I'm sure I didn't understand it, and so maybe these are it here and they were just two words that were struck, did what I'm suggesting here. But the presumption for the A&R permits in Act 250s, we'd like to see that provision added to the bill if it's not there. It was in the discussion draft from January 14th, so I just kind of referenced the page and section where that language was in that joint proposal from the administration of the NRC. And similarly, we support the exemption that was in that joint proposal for the exemption of transportation projects that don't disturb more than an additional 10 acres. So that is my comment. Sorry to run through that so fast. I feel like I was talking at you very fast or quickly, and welcome any more questions, or else I will just thank you for listening.
oh, well, Jim,
Transportation projects.
Yep.
It concerns me that there's a real possibility in the design and construction phases that will lap out into the previously disturbed areas, and be that the case, I think those areas should be considered in the plan, and I'll cite and I'm not getting the chemical right. That Burlington, for instance, is experiencing the trees, leaves soak up the chemical from vehicle and furnace exhausts, and then they go down on the ground, and then they get in, and actually that soil is so contaminated that I'm not sure we still know what we're doing with it. For a while it got transported to Coventry, and now it's being like stockpiled, I think. And so if we just don't look at any of that area that was previously permitted, I'm wondering if we're missing something. Thoughts on that?
Yep, probably multiple thoughts. I guess a couple perspectives. I'm not questioning that we shouldn't have any environmental review. I think, you know, it's just whether the Act 250 review is needed in addition to the environmental permits.
Parsing that out, yeah.
Yeah, so I don't wanna like do whatever permitting to protect the environment needs to be done,
Yeah.
stormwater,
Through
weather
the
pollutants,
agency.
through the
Yeah.
agency,
Yeah.
right. And that's really, I guess partly what I'm saying with regard to the transportation projects. Those have to get all those environmental permits anyway. We have not seen Act 250 really add much value to the transportation projects other than to provide a forum for appeals. And, you know, which, you know, certainly an applicant, or a neighbor or whoever could appeal the state permits, the environmental permits as well. But, you know, the projects have already gone through, and we're painfully aware of the public process that we go through when we're developing a transportation project with V-Trans. And so there's plenty of public review already that happens on these projects. And I guess from our view, we're not seeing a lot of value added from the Act 250 review for projects that are minimal. Like they're not really adding any substantive new, you know, we're not adding a new road. If we're adding a new road, fine,
Yeah,
Act 250.
yeah.
You know, adding a new lane on 89, Act 250. But for the smaller projects, it shouldn't be there just because they're doing reconstruction of the existing road.
Thank you.
Yeah, thank you.
Anyone else? Thank you very much, appreciate your comments.
Yeah, thank you very much, appreciate it.